What's up, everyone? So, in this episode, we're going to be talking about your lease packets. If you're a buy and hold investor renting properties out long term, you have a lease packet, which is basically the document you give to your tenant that says, this is what the terms are, this is what the rules are. But what I've realized after 25 years of being cognitively aware in this industry, so since I was about a teenager and I started paying attention to certain things, leases vary dramatically. And that's not necessarily a good thing when I'm saying that. When I'm saying that, I mean, I see leases where I wonder, why did you bother even putting that document together? And then I see leases on the other side of it where I'm like, whoa, you literally have everything in there. Like, I swear they have every possible circumstances covered. Obviously, there's some sort of good middle ground. So, we're going to talk today about your lease packet, what documents should be in there, maybe what clauses should be in there, what you should be addressing, so that you can put together a lease packet that protects not only you, but it protects you without infringing on the rights of the tenant. And there is a fine line there. This is something a lot of landlords don't understand, especially ones that are the less educated. They don't understand that your rights have to be balanced with the rights of the tenant. So, we're going to dive into a deep conversation about your lease packet today. Building a real estate portfolio is as much about buying properties as being a de facto entrepreneur. I'm Karina Ufinger. I'm a multi-property investor, rental management company CEO, and also a landlord coach. I'm going to show you the systems and knowledge you need to thrive as a real estate entrepreneur. From your first property purchase to building a portfolio of passive income where you work less than 5 hours a week, you'll learn the essential information and skills to build a profitable portfolio and live the life you truly want. Whether you're well on your journey or just starting out, you're in the right place. Welcome to the Landlord Chick podcast. As we jump into this conversation, I want to get three things sort of out of the way. The first is some definitions. So we have rental agreement and we have lease packet that we're going to be talking about. A rental agreement is a component of an overall lease packet. So the rental agreement is sort of like the top sheet or top couple sheets of a lease packet. This is where the tenant is finding out what their address is, what the rent is, where the security deposit's held, who's paying what utilities. That's all covered in the rental packet. Your rental agreement. Then the lease packet. That consists of the other documents that are attached to that rental agreement. I will say this, that chances are you have to have additional documents attached to your rental agreement, if only for the purpose that the state requires some additional forms. So in your state statutes, and we're going to be saying this a lot, so I feel like we should have like a little bell that we're ringing every time we say check your state statutes or in your state statutes. But anyway, check your state statutes to see what other documents are required. Here in Wisconsin, we are required to have 2 additional documents in our lease packets. The first one is the smoke and carbon monoxide detector agreement, which basically outlines the responsibilities between the landlord and the tenant about those items. The other document that we have to have in our lease packets is a non-standard rental provision. A non-standard rental provision is not anywhere near what it says. A non-standard rental provision is a document which outlines the fees or fines that a tenant can incur during a tenancy that you want to have withheld from the security deposit. So those are the 2 additional items that we have to have that make up the lease packet in addition to the rental agreement. So be sure and check your state statutes to see what's required of you. I think most states nowadays are requiring the smoke and carbon monoxide detector agreement, and it's very possible your state has other additional forms that are required. The other thing I want to say about rental agreements in the introduction here is that if you are a person who chooses to do a Google search to find a Utah lease agreement, Utah rental agreement, I want to encourage you to use a little bit of caution. There's a lot of sources out there for buying these things pre-made off of the internet, and they have what I call boilerplate language. So they have language which is meant to be generally applicable in every state with maybe slight tweaks for deadlines that are easily researchable. Here's an example. You might get a rental agreement from maybe Rocket Lawyer, and they say attorney reviewed or attorney drafted. They might not be attorneys that practice law in that state, but they are licensed attorneys in some state. And what they likely did when they were reviewing this was they Googled, what is the security deposit return deadline for Utah? And they inserted, I'm going to make up a time frame here, 30 days. They put 30 days in that blank, in that boilerplate language rental agreement, and that was the change that they made. They didn't go further into Utah state laws to figure out if there were other requirements on the landlord for security deposits. So when you use anything that's purchased off the internet, if you aren't entirely sure it was reviewed by an attorney that's licensed in your state, a great way to find out is that all these forms should have the attorney who drafted it or reviewed it in the bottom corner somewhere. Take a moment to Google that attorney's name and see if they come up as licensed in whatever state. So I'm going to use George Washington. Let's say there's an attorney named George Washington who's still alive today. You Google George Washington and you put in George Washington, Indiana law and see if he is licensed to be an attorney in Indiana. If he is, chances are he has a fairly good grasp on the ins and outs of the state statutes. Now, here in Wisconsin, we have a great resource called Wisconsin Legal Blank. What I love about Wisconsin Legal Blank is that all of their forms are attorney drafted or reviewed by a gentleman who is considered the star real estate attorney in Wisconsin, and that is a gentleman named Tristan Pettit. So this is a great source in Wisconsin that self-managing landlords have for getting lease documents that are going to be in line with state statutes. I would suggest that if you are in another state, start asking around to people, other investors, to see where they purchase their rental agreements and see if there's a locally reliable source, such as Wisconsin Legal Blank, like we have here. So now that we got that out of the way, I want to kind of get into the meat of our conversation here, which is creating your leases. Your lease is your second line of defense. I always say your first line of defense is your tenant screening, but your second line of defense is going to be your lease. Your lease informs the tenant of not only what to do, but what not to do. And it also informs them of what you're not going to do. So for instance, you're informing them that your late fee is $50 and that is charged on the 5th day of the month. You're not going to charge them a late fee on the 3rd day of the month or the 2nd day of the month, and it's not going to be a daily late fee. So you're outlining what they have to do, what they can't do, and what you will or will not do yourself. Now, if you haven't had the experience of going to court yet, let me give you a little inside experience. One of the first things that a judge is going to do when you arrive at court is they're going to ask for your full lease. And they're going to say your full lease. So they're meaning all the addendums that are attached to it, as well as that top sheet, the rental agreement. They are going to start looking through your lease with a fine-tooth comb. They're going to start looking at all the clauses and making sure that they are in accordance with the state statutes. So it doesn't matter if you're in front of the judge for a matter that is completely unrelated to a clause in the lease. If the judge finds the clause in the lease, that's a problem for you. It's a problem for you because depending on what's in your state statutes and what may not be in your lease, is if a judge finds a lease clause that is invalid, the entire lease could be struck down. Now, here in Wisconsin, we recently had a law put on the books, I want to say in the last like 5 years or so, that gave every landlord the right that their entire lease would not be invalidated if one clause was illegal. If you don't have that clause in your statutes, what you want to have in your rental agreement is language that says that this rental agreement is severable, which means that you can pull out the illegal lease clause and the rest of it will still stand up and be held accountable. So it's important that your lease is fully legal, because judges do not look at leases with blinders on. They don't go, okay, I'm just here for something with delinquency and rent collection. I'm only going to focus on those lease clauses. They're going to look at every single lease clause. The other thing they're going to be looking for is making sure that what you are trying to enforce upon the tenant is explicitly included in your lease. And I mean explicitly included. This is where you need to be sure that your language is not too vague. You want to have language that is specific enough to get a point across, but not too specific where it doesn't include everything you mean for it to. And there is a line that you do have to walk with that. So it's important to make sure that all your lease clauses are valid, or that you have that severability thing in there if it's not covered by your state statutes. And you also want to be sure that your lease clauses are not too vague. So how do we structure our lease packets? How you structure your lease packet is mostly up to you. I say mostly, referring back to the conversation about state-specific forms. Beyond that, it's up to you whether or not you create forms for specific groupings of rules, or if you just drop them into a rental agreement that you're making up, or just add everything to your rules and regulations. Beyond having a rental agreement, a non-standard rental provisions, one of the things you will always find in any lease packet I am attached to is a rules and regulations. So this is the sheet that I use to cover everything else, basically. Now, I used to be a person who preferred to have a separate page for groups of lease regulations. So I used to have leases, and this is not an exaggeration. I used to have leases that had a no pet statement, leases with a pet policy, leases with a garage rental agreement, leases with a vehicle policy, leases with a washer dryer agreement, leases with move out expectations. I feel like I'm missing one or two big ones, but I really did have a large number of additional documents that made up my lease packet. Then I realized, number one, how annoying getting that many signatures was. But I also realized how much paper I was wasting and if it ever got printed out. And then I also realized how much time my staff was wasting by appending various individual PDFs to make a complete lease packet. So I changed my strategy to only have separate documents as what was required by the state, or what were optional forms based on a tenant's personal choices. So that comes down to pets, whether they're renting a garage from me, and that's really about it. Everything else now I've managed to incorporate into the rules and regulations. So what are the separate forms that you might want to have? So here in Wisconsin, in our lease packets, we have to have the non-standard rental provisions. We have to have the smoke and carbon monoxide detector. I do have a few other specific forms that might be attached to a packet. And again, that all depends on the tenant's choices. So the pet policy, because not every tenant will have a pet, I have a separate form for that. A garage rental agreement, that's if someone's going to rent a garage from me or the property owner. And then I also have what is the move out expectations. Now, the move out expectations is one of the forms I get asked about a lot when people hear me talk about it. Like, wait, what is that? The move out expectations not only necessarily sets the procedure for what happens during the course of a move out, that 30-day period here in Wisconsin, but it also covers how I want the unit turned back over to us. So we're giving them instructions on how to clean, and we're also making it clear what they're going to be charged if it doesn't meet those expectations. And I really love this form because since we started including this, it's made a drastic change in how units are turned back over to us. Between that and our tenant screening, we are getting units turned back over to us in better condition overall than we ever had before. And it's because people know the monetary consequences of not cleaning out the fridge, of not cleaning the windows. They know the monetary repercussions of having a stain on the carpet. Knowing all this ahead of time, they try and avoid having those things happen. As I said before, I also have a rules and regulation sheet, and this lists every clause I want included in my lease that either doesn't come on the pre-printed rental agreement or it isn't worthy of an entirely separate document. A great example is I used to have a separate form where a tenant declared that they had no pet when they were moving in. I decided, you know what? That's a kind of superfluous form. Why don't I just make one of the clauses of rules and regulations that unless it's otherwise stated in this lease, pets are prohibited? In that same part, I go into a little bit about what the pet policy might look like if they choose to get a pet, if they can get a pet. I want to point out that, as I stated earlier, the more additional pages you have to a lease packet, the more signatures are needed, and this can be a little annoying because every document that you attach to a rental agreement that you want to enforce in the court has to have a tenant signature on it. So creating a lease packet with 6 additional addendums requires 6 additional signatures, not only from the tenant, but also from you. So that's just something to keep in mind as you're creating your lease packet. So what should we be covering in our rules and regulations? Beyond other items that we talked about above, what should be covered in your rules and regulations? This is going to vary by the type of property you have and also by your own preferences. This document should include any rules you want to be able to remove a tenant for violating that aren't included in the rental agreement otherwise. So here's a couple of good idea clauses. Room and window AC units. Because I have units that don't have central air, I often had people putting in window ACs. Window AC units are nice because they're cheap, they're portable, but they have to be installed in a particular fashion, or else the drainage from the AC units can cause damage to the walls, the window frame, and it can create a huge situation. I've had this created twice in the past 3 years by tenants not properly installing a window AC unit. So what I recently did was in my rules and regulations, I banned window AC units and I said tenants are free to use room AC units. However, individual window units are banned and are not able to be used on the property. So that's something that I would consider you having in there if you have issues with AC units. You could also put in there instructions that the AC unit for the window has to be tilted in a certain direction to avoid wall damage, sort of giving them the heads up on how to properly install them. Another clause you want to have in your rules and regulations is about noise violations. So it's a good idea to cover quiet hours, what constitutes a noise complaint, and what the consequences are. Quiet hours for my rentals are from 9 p.m. to 6 a.m. So it's really important that you have something in there that gives guidelines for what a noise violation is and when quiet hours are. A noise violation in my lease is anything that disturbs the enjoyment of other tenants within reasonable expectations. Obviously, somebody dropping a mayonnaise jar on a second story apartment at midnight is not a noise violation. But coming home from maybe your second shift job and playing Breaking Bad at full volume would probably be a lease noise violation. That's going to disturb other tenants during quiet hours. And that would actually apply if it wasn't quiet hours as well. And that's an important thing to put in your lease as well if you're going to address noise violations is you don't want to have it be quiet hours are 9 to 6. This is what's prohibited during quiet hours. Quiet hours are 9 to 6, but also during all hours be courteous of your neighbors. Another aspect to have in your rules and regulations is how many strikes a tenant gets before they're gone. So, what is the quota for how many warnings or violations a person gets before they are in danger of their lease not being renewed? It's important to mention that violations don't need to be for the same offense. So, you want to put in there that a tenant can have 3 lease violations during the course of the year, and they can be for any clause pertained in the lease. Another section I encourage you to have, and we just recently talked about it, was a pet policy or animal policy section. It's a good idea to put in your rules that unless a specific addenda is attached, that pets are prohibited. In the same clause, it makes sense to explain to them the penalty for the violation and then also give them a heads up on what the pet rent might be or the deposit for the pet. It's also a good idea to include any breed or animal restrictions. You have that in there because what it does is it avoids complications and confusions down the road. The last thing on earth you want, and this is actually something that happened to me. I had a family that I was renting to. They wanted to get a pet. They asked, can they get a dog? Yes, you can get a dog. We weren't explicit enough ahead of time with what some of the breed restrictions were. They came back with a pit bull that their children had fallen in love with. Now, I know pit bulls get a bad rap. They get an absolutely bad rap. But unfortunately, in some situations, especially when you're dealing with very large multifamily, your insurance company will be the ones to say, sorry, no pit bulls. So in this instance, that was actually the issue. The insurance for the property said absolutely no pit bulls. This family had found a nice pit bull. Very, very sweet. But alas, it was still a pit bull. They could not actually continue to have that dog live on the property because it was a violation of the owner's insurance. Ever since then, I've made it a point to be sure that everyone knows breed restrictions, animal restrictions immediately when they move in. Another area you want to have covered is common areas. If your building has common areas, whether it be in the yard or interior, you should include rules regarding personal items in common areas, smoking in common areas, and loitering in common areas. Here's my little pro tip. It's best to be specific about limiting items in the common area. We limit personal items in the common area on the interior to one wall or door hanging decor that is attached with 3M strips and up to 2 items on the floor outside of the doorway, including shoes. I do want to add here that if you're If you have common areas, it's a really good idea to check your local fire codes. Hey, ring that bell again about check something local, because your fire codes will likely have additional restrictions. There might be no personal items in the hallway. There might be a specific like footage or inches of clearance that are needed in the hallway. And that's all stuff that you want to be sure to include in your lease packet, because it's going to make it easier in the event you get called on anything. You can say, hey, it's in your lease that there needs to be 12 inches of walking space in the hallway on both sides, and there's not that. Another section to include would be any personal vehicle restrictions that you want to have. This is for not only the storage of like boats, RVs, or driving of ATVs, but it also should include items regarding parking. So, no parking on the grass. If there's assigned parking spots, that should be listed there. Those are all good things to include as far as personal vehicle restrictions. Now, there are some other areas that I'm not going to really go into, but some of the areas I suggest you include are interior painting, whether or not a tenant can do any sort of interior painting, maintenance items that the tenant may be responsible for. And then another good suggestion I have for you is outlining what your payment agreement rules and policies are. I have an entire podcast dedicated to payment agreement rules from the beginning of the COVID pandemic. So it probably was out sometime in March, April, or May of 2020. So check that one out if you need any help with payment agreement guidelines. All right. So then, do you need a different lease packet for different types of properties? The easy answer is usually no. Generally speaking, in most cases, you don't need to have different lease packets for your single family home versus your duplex. The only time an entirely different lease packet might be justified is when you start getting into medium or large multifamily, so 6 units or larger. If you have a portfolio with single family homes and duplexes, you can probably get away with just one lease packet, and if needed, a particular section that would apply to duplexes or to single family homes, depending on where the differences in the regulations lie. Lastly, I do want to point out that, again, if you're going to draft or buy something off of the internet for your rental agreement or any packet, I highly recommend having it reviewed by a real estate attorney in your state. It's less expensive to have them review a document than having them draft it. See, drafting a document takes maybe 3 hours. Reviewing a document takes maybe less than an hour, but you're going to get charged likely 1 hour. There's a huge price difference in those two. If you get your rental agreement from an online source, definitely have it reviewed. If you draft your own, definitely have it reviewed. If you did buy one from the internet, just because you purchased it with a guarantee that it will work in your state doesn't mean that that protection will save your tushy in court. Because the fact of the matter is that if you purchase a lease off the internet, you take it to court, it ends up in court, and the attorney says this clause is illegal, you don't have a defense in, oh, well, the company says that they guarantee it. The judge isn't going to care. You're going to be the one on the hook for using that lease with that invalid clause. So it's really important to have your lease reviewed by an attorney, whether you buy it from the internet or you draft it yourself. That completes our little session on creating your lease packet. If you guys have any suggestions for future episodes, please hit me up over on Instagram, a landlord chick. You can find me over there. You can find me on Bigger Pockets. My name is Karina Ufinger, in case you don't know that. Find me on Bigger Pockets. Find me on Instagram. You can find me on LinkedIn, but I don't know what good that'll do you because I just kind of copy and paste and post stuff there. But if you want to follow me and follow what I do, I have a blog on Bigger Pockets. I have my Instagram profile, all these great things out there for you to keep in touch with me, find out what I'm up to, and ask me questions. A lot of your questions end up inspiring a podcast episode, so please continue to send me your questions or just specific requests for a podcast episode. Until then, I'll see you guys later.